breach take place on 3rd of May. Now, what is the investigation on that angle? But if I can invite your kind attention to the news item, this is Times of India. Page 12 of my first supplementary note, I have placed the Times of India report. If I can just read a few lines from here. The sources told TOI that CBI attention turned to Oasis School located in Mandai Road, Kali Chowk, and its staff. The agency began gathering digital evidence and discovered that e-rickshaw had gone directly to Oasis School on May 3rd instead of proceeding to the SBI main branch where it was supposed to be stored. This is a report quoted by Times of India from the source of CBI. Now, what they say, except saying that it is because the report is somewhere below the e-rickshaw, Indian Express says it is OMR. OMR will not go into trunks. Let me explain this. As per their case, after examination at 5:20, the OMRs are to be collected. They have prescribed a specific cloth under which those are to be sealed, and those are to be given to the city center. There is one center in the city where all this is to be deposited. Hazaribagh, what was the center at Hazaribagh where these OMR sheets were to be finally deposited? And how come this, again, it is being, e-rickshaw is taking these OMR sheets? In a center, if there are, I do not know how many students are there in this Oasis school, but even if there are 200, 300 people, these are 300 pages. Those 300 pages will not go into the trunks and e-rickshaw. There is something which do not meet the eyes of this honorable court. Everything is not placed before this court. So, they have not come clean with regard to Ghaziabad. They have, yesterday, saw it with regard to Bahadurgarh. They first said Hardayal school, they attempted full-time Canara Bank paper. They said that for the other centers, we gave the grace marks. Then today they say, no, the other centers, we didn't give the grace marks because there was a loss of time. We gave them the extra time. Now, who decided? There was a loss of time in, maybe in Ghaziabad, loss of time in Rajasthan, Savai Madhopur. There they did not give extra time to attempt the same question paper. They asked the student to rewrite between 6 to 9. And in Bahadurgarh, some superintendent, all these private people, they took a decision that, all right, we extend it for 1 hour or half an hour. May kindly send for the files as to who was competent to take this decision, who actually took those decisions. Are the principals of the school taking these decisions? How they picked up and chose 1,563 people? Who took those decisions? What are the file notings? What are the communications? Their only object as of now seems to be that anyhow we persuade this honorable court to sustain the examination, come whatever may. The entire confidence that the leak is limited is born from the fact that accused are saying that it is not beyond Patna. Why would the accused will confess that we have 100 other post-dated checks which are lying somewhere else and we had supplied question paper somewhere else also? At least CBI did not sound that confident that there is nothing beyond Patna. The expression used was so far. So, I would at the end conclude by saying this: there is absolutely no sanctity left. There is no SOP, there is no system fix that how soon the OMR sheet is to be sealed. I'm sorry to repeat it. And there is no system. May kindly notice this. There is no time frame given for sealing of OMR sheet in their SOP, which I have placed on record. They did not think it appropriate to find that if somebody living in Gujarat is applying for Maharashtra and giving address of Maharashtra, why wouldn't they ask the candidate to submit a proof? We go for a ration card, they ask for a proof. for an Aadhaar card. Aadhaar card is almost everyone. I'm sure all these 22 lakh candidates had the Aadhaar card with them. Why they are permitting this kind of malaise in the system? So grateful. Much obliged.
One,
Please, please.
this woman aside, would I substantially
Yes,
argue
yes, yes, yes.
just one
So,
bullet points?
Your Lordship's question that today, given the situation that the investigation is incomplete, the investigators have told Your Lordships that it is possible that about 155 students alone were involved, only 155. It is not fair to upset nearly 24 lakh students. That is the question that Your Lordships had. Would it be in those circumstances fair to upset the entire exam? Firstly, my lords, what Your Lordships should examine is what has come out in this hearing so far. Has it reassured Your Lordships that a fair exam was indeed held? That when there was unfairness which was reported, was it fairly investigated? And what the investigating agency has told Your Lordship, that it took place at a very brief point of time on the day of the exam, and therefore the contamination was very limited. Is that something which Your Lordship would place reliance on? I'm going by exactly what the CBI said. The CBI says that there is an organized mafia in these matters. They work on a business proposition. 3 months prior itself, they have sent out their agents saying, if you are willing to pay, we will get you the paper. And we will see to it that you get a rank of your choice. Now, what the CBI has told you is that the leak has occurred between 8:02 and 9:26 on the morning of the 5th. When one Mr. Pankaj Kumar goes into that room in Hazaribagh, extracts the paper, takes photographs, reseals it in that envelope, closes the trunk, comes out, and only thereafter physically goes to another place in Hazaribagh, gives it to the solvers, or from outside after. So that takes it to around, from 9:26, it takes it to 9:30. Your Lordships will mark the timeline from 9:30 to 12:30. That is the timeline that the CBI has told Your Lordships. At 9:30, if the papers, photographs are either taken physically or WhatsApped, then the solvers are split, and let's give them another half an hour to answer 30 questions, 20 questions each that they get. That takes it to 10. Between 10 and 12, because 12:30 they're dropped off back. Students are supposed to have read the papers and memorized it, and then gone. Now, my lords, for that uncertain chance of 2 hours, which parent will pay 30 lakhs to 75 lakhs in advance? Please take just that. That is why it is implausible. there anything yet? Bring up. Please, my lords. Now, my lords, I do not have the benefit of any of the reports, but I am going by the by the first FIR which the Patna police registered. And I submit to your lordships that where it is clear that on the night of the 4th, the students had solved papers and were asked to memorize. And despite all that, they still failed. So obviously, when preparations are made for people to pass exams or to get a good rank, they need adequate time. This kind of timeline does not work. This brief 2-hour intervention, my lords, is not plausible. And in fact, the OSS school from where it was, where this leak happened, there is a video of the principal saying that when the earlier EOU asked, showed him how this had happened, their conclusion seemed to be that the leakage happened before the papers went into the bank. There is a video of the man when he was not under arrest. The leakage has probably happened on the 3rd. It happens in Hazaribagh. It is caught in Patna. And it is at the behest of Sanjeev Mukhia, who has not only a history of conducting leaks, he is now a big investor in leaks. Okay? My lords,
That now Mr. Wood
yes,
has argued.
that he's argued.
Anything else that you have to add?
Please, my lords. The question is, what is the precedent that 3 of your lordships will hold? Most of the judgments that your lordships have delivered are 2-judge judgments. And if your lordships were to be called upon to say that, look, this much of a leak or of a localized leak is not something which we will interfere in and which we will possibly say, for want of a better term, wink at, then as a lawyer, I might tell your lordships that for the next 20, 30 years, we will be forever striving to say, no, this is not a leak of that kind, this is a leak of this kind, and it is such a small one. So there, my lords, just before I end, my lords, this precedent point came up much earlier, where the argument was made as the solicitors made. And I beseech you, rest once the law to your authority to do a great right, do a little wrong. And Portia's answer was, it must not be. There's no power in Venice can alter a decree established. It will be recorded for a precedent. And many an error by the same example will rush into the state. It must not be.
Yes, thank you, Mr. Wood.
I'm
Yes,
grateful.
my lord. I wanted to answer one question of Justice Pardivada and Justice Your Lordship's question. And when the questions are raised, any member of the bar who was actively participating in the discussion can certainly answer it. And I did not do anything wrong. And I'm sorry, I was unfairly treated. That's a different story. Now, that's a different story. Let me come into the case.
Make your submission.
No, coming to the state. Yeah, my lord. Now, I'm amazed by the kind of discussions which has been going on here. We have been conducting a criminal trial. We are going to the niceties. We have called the CBI. But solicit what kind of discussions which have been going on. The issue is, you ask a common man, a man in the street, there is an examination leak. I came, my petition, I said only one thing. There has been a leak. A leak has been happened, then there is no alternative. There is no alternative than a retest. It certainly leaves inconvenience. Certainly. And only thing that can be thought of is how to reduce the inconvenience. And I made a suggestion, which my friend also adopted, that this test be conducted as a NEET preliminary examination. 13 lakh students are qualified, and they be taken for the final examination. And this is an administrative issue. Today, because of PILs, etc., we treat many things which are in the realm of falling in the exclusive realm of governance into the court. And my lord, therefore, this is something the government did a great injustice to the court. The government it was their problem. It was a issue of governance, and the government very conveniently did not raise the maintainability of these petitions, allowed questions, the detailed arguments to be made for days and days, and they're literally shunning away from their responsibility. There is a government. This is an issue concerning lakhs of people. It is a call of the minister. It is a call of the government. And the government has failed to. I'm not anti-BJP man. In fact, I supported BJP. I advocated for voting for BJP. But what happened today? This is something utterly, I'm not using a very strong expression, unacceptable. The government of the day is accountable to the people. When your lordship, I always say, when your lordship takes a decision, my lord, that only binds the parties before you. When a parliament takes a decision, we are all present in the parliament, and we are symbolically present in the parliament. It binds all of us. In the last couple of years, the governance, what the parliament ought to do, what the government ought to do, the courts are forced to do. Courts are forced to do. Therefore, my lord, the question today is, what is the given situation, what is to be done? Admittedly, there is a leak. And this leaves no option than to cancel the examination, as rightly Justice Vikamnath has said, 0.00% doubt, examination has to be cancelled. And that is the only option. This is a matter which should have been concluded in 20 minutes. And good that we spend a good lot of time. I'm no quarrel about it. And therefore, my advice to the court is that court should not enter into the domain of the executive. Let the government do its job. Let the government answer to the people. The parliament is going on. Session is going on. The very NEET issue is before the parliament. And here is a Solicitor General. He doesn't even oppose. I'm for the petitioner. I'm strongly advocating the cancellation of this examination. Still, I said, as a matter of principle, a lawyer has to speak about the fundamental constitutional principle. A fundamental constitutional principle is that these are our administrative issues, and if, assuming that the government, at least the matter should have been relegated to the government should have directed to take a decision. And the government, supposing that the government has taken a decision after hearing both of us, parties affected, not only those who are asking for cancellation of the examination, but also those who are asking for non-cancellation of the examination, because they are the ones who stand to benefit by the results. Both parties, to the extent possible, unlike a court, the government is under no obligation to hear everybody. Because the government represents the people, and therefore no obligation to hear everybody. But court, when a court decides a matter, it is under a duty to, my lords, listen to everybody. Otherwise, my lord, that res inter alios acta, altori, noseri, non debet. Court has no jurisdiction to bind anybody who is not before it. So having this fundamental principle being stated, and whenever every PAL comes before this court should certainly adjust to itself. The people affected are not here, and we don't represent the people of this country. And these issues concerning the public at large cannot be decided behind the back of them. These proceedings are not representative proceedings. These are proceedings, in my case, 16 students were affected by it. Therefore, my lord, when this case came, the only option is to throw the ball back to the government's court, and the government to take a call on the question of cancellation. And the government would have done it in moments' time. It wouldn't have been able to justify this examination, not even one moment. The government would have come with the conclusion, the decision to cancel it forthwith. And the government conveniently, very conveniently, saying that is a non-adjudicatory, the Solicitor General says, non-adjudicatory litigation. What is that? Non-adjudicatory. There is nothing like non-adjudicatory. Court's job is to decide disputes. Court's duty is to decide disputed questions of fact. and apply the law. If the issues are non-adjudicatory, there is nothing. It is administrative. And my lord, I conclude by saying one word. My lord, I forgive your lordship for all the insult to me and my lord, humiliation. I forgive your lordship, Lord, forgive them for they not know what they are doing. I have nothing in my mind. I have the greatest of regard for your lordships and lordship Padiwala also. I have the greatest of regard, though I was insulted. I don't keep anything in my mind. But my lord, this NEET examination has to be cancelled forthwith. It cannot be delayed 1 minute because precious time of the students are lost, and a fresh examination has to be conducted forthwith. And it is for the government to decide whether it has to be for the 13 lakh students who was selected, or it has to be for a lesser number. And these are areas where the court should step in, because what is governing the matters of administration, but those in governance alone come to know about it. Somebody said it's certainly NEET is a very loosely conducted, all outsourced. But that is true. But in a governance, outsourcing is necessary, without which no government can function. Everything, the NEET department cannot do it. So most of the things which my friend Hoda and Sanjay Khadge argued, with respect, I disagree with that. And only my submission is, this is an issue which will be thrown to the government's court. Let them decide. Let them decide. Let the parliament is going, let them answer to the parliament. And let them not shirk their responsibility and throw all public issues to the court's domain. Because I say so, because average time, which an ordinary litigant who comes for a grievances, is 93 seconds. When I come to your lordships for a SLP, it is dismissed in 93 seconds. And I had a recent incident where my SLP was dismissed even 60 seconds. So therefore, we have to revisit it. The PA business has to be discouraged. And only petitions, here, at least affected parties are there. My petition is not PAL. My petition is somebody who is seeking declaration of their fundamental rights. And my lord, I conclude, the research has to be cancelled, examination has to be contested. Greatly obliged.
Please, just 2 minutes.
Your Lordships.
Your Lordships asked a question to senior Lords, that in this situation, what your Lordships should be doing in case whether the investigation is yet not complete. Because this has been answered in that judgment which I referred yesterday. I just want to repeat a paragraph so that will assist your Lordships. Before that, that's Tanvi Sarwal was not cited before your Lordships in the Sachin Kumar's judgment. I tried to check it. That's also a 2-judge bench judgment. This is also 2-judge bench judgment. So this was not cited before your Lordships. That's what I could.
No, but the subsequent judgment which I decided was a case where the government had decided to cancel the entire exam.
So here,
So there was no question of the court being required to cancel the exam. So the legality of the decision of the government to cancel the entire exam wasn't called into question.
Please,
that was
here we are not able to segregate the tainted from the the good people. Just Lordships, you may see paragraph 18. If Lordship wants, I can. Para 18 2015 6 SCC 573. The same situation before your Lordships, as in today. Third line, though as on date 44 such candidates have been identified, having regard to the modus operandi put in place, the number of cell phones and other devices used, it is not unlikely that the many more candidates have availed such undue advantage. So many more.
Para 15 is relevant. Para 15. 1-5.
Let's read para 15 and then.
Yes. The investigating agency in its report has stated in clear terms that from the disclosure recorded, it is beyond doubt that the strategy of providing answer key has been executed by an organized gang with a network spreading over different parts of the country. The Inspector General of Police, who was present in this with his team, having been granted the leave, submitted that the investigation is full swing and in progress, etc., etc. It was their case that it's pan-India.
So, here today the situation is they themselves are saying, that we are yet to investigate further. Now that is also looked into in paragraph 18 if your Lordship sees.
Right, let's see.
Yes, though as on date 44 such candidates have been identified, having.
So the last line he says, frankly, admitted that in process it might not be possible to identify. But it's an all India issue.
Para 18 now.
Yes, para 18, third line, though as on date 44 such candidates have been identified, having regard to the modus operandi put in place, the number of cell phones and other devices used, it is not unlikely that many more candidates have availed such undue advantage being a part of the overall design. and in the process have been unduly benefited qua the other students who had made sincere and genuine endeavors to solve the answer papers on the basis of their devoted preparation and hard labor. In view of the widespread network that has operated, as Milord, in this case it appears so, as the status report disclosed, and the admission of person arrested, including some beneficiary candidates, we are of the opinion that in view of the strong possibility of the identification of other candidates as well involved in such malpractices, that examination has become a suspect. As it is, the system of examination pursued over the decades has been accepted by all who are rational, responsible, and sensible to be an accredited one for comparative evaluation of the merit and worth of candidates vying for high academic pursuits. It is thus necessary for all the role players in the process to secure and sustain the confidence of the public in general and students fraternity in particular in the system by its unquestionable trustworthiness. Such a system is endorsed because of the credibility informed with guarantee of fairness, transparency, authenticity, and sanctity. There cannot be any compromise with this imperative at any cost.
Also,
So, even at the cost of 44 students and a possibility of more people being found, so your lordships did set aside, because the learned solicitor general said 2 lakhs, because my information is there were 6 lakh students. This is the same API, All India pre-medical test, the same which was to happen before NEET started. And it is to be conducted by CBSE in that. Yes, Milord. Para 19, segregation only of already 44 identified candidates stated to be the beneficiaries of the unprincipled maneuver by withholding their results for the time being, in our comprehension, cannot be the solution to the problem that contours all of us, that confronts all of us. Not only thereby, if the process is allowed to advance, it would be pushed to the vortex of a litigation pertaining thereto in the foreseeable future. The prospects of candidates would not only remain uncertain and tentative, they would also remain plagued with the prolonged anguish and anxiety if involved in the ordeal of court cases. Acting on this opinion, option would, in our estimate, amount to driving knowingly the students who are not at fault to an uncertain future with their academic career in jeopardy on many counts. Further, there would also be lurking possibility of unidentified beneficiaries of the candidates stealing a march over them on the basis of the advantages availed by them through the underhand dealings as revealed. Having regard to the fact that the course involved with time would yield the future generations of the doctors of the country who would be in charge of the public health, their inherent merit to quality for taking the course can by no means be compromised. So, Milords, even if 10 to 20,000 students come up in the front and I am pushed outside the 1,08,000, Milords, ultimately my chances.
Anybody else?
Only one more
Your
thing.
Lordship,
Lords, one more thing. Lords, your Lordships yesterday had indicated the issue which I said was the OMR sheet issue. Your Lordship said it's a personal issue, Milords, an individual client. Milords, the OMR issue, Milords, sorry. Because in the OMR issue, in fact, it appears to be a part of the systematic failure because it's not only my client, because she has not given the, she has not been given the OMR sheet. When the OMR sheet, when she got initially, she calculated it came to 650, around 650. But when the result came, it is 103. They have been emailing to the NTA, give the OMR sheet. They have not given till now, Milords. So, Milords, and others also.
Lordship, my one submission is a very important thing to say. Lordships, then my solicitors and CBI entire focused only here the
Like,
Hazaribagh and Patna. Lordship, it is the not focused here the 5 layers scams. Point number 1, Lordships, there is the before of the examinations. Point number 1, it means there is 9 February 16 months before. Second is Lordships, when notifications came, it means there is the forms filling forms. It means 9 February to 16 March. In which regions a lot of candidates appeared in the different centers. Next is third layer, is the Lordships. The examination dated, it means the conducting jobs 5 May. 5 May, in which regions a lot of candidates, some are the belong from the Odisha to appeared in the some other places. In which regions, Lordships, it is the SBI and Canara banks and other types of the issues. It is the not given in the submit is the reports. Third is the Lordship, the after examinations. There are a lot of issues in which regions the 720 marks, which is got by this out of the 720s, 718, 719, 600 and above. And Lordships and others issue the 4 and 6 layers. The Lordship, my humble submissions, please Lordships, On the behalf of the petitioners, Lordship, please reconduct the examination.
My lord,
Lord, in item
submissions for the applicants in IA number 137554 of 2004. Lords, we stand for some of the candidates who have secured high marks. But one submission I would like to make, so far as a leak or theft elsewhere than the 2 or 3 identified places are concerned, I would submit that a decision may not be based on suspicion or conjectures, because these are all matters to be proved beyond reasonable doubt. I would like to suggest one decision, Lords, AR 1994 Supreme Court 626. AR 1994 Supreme Court 626, where at paragraph 44, the Lordships refer to the Privy Council decision. Of course, it concerned fraud alleged in a civil proceeding. Now, it is held at paragraph 44, my lords. Mary, in so and so, AR 1941, Privy Council 93.
What is the name of the case?
Lords, it is, Svenska and Svenken appellant versus Indian Charge Crop and others.
It's on bank guarantee.
Not bank guarantee. So that's right.
Fraud or bank guarantee.
I only submitted that it concerns allegation of fraud in a civil proceeding.
Fraud unravels the reason. You got your point. Thank you.
Proof.
Your Lordship.
One more submission, Lord. One more submission, Lord. So far as the question, the particular question is concerned, eligibility for NEET test is the board examination. The board examination prescribed the NCRT books. And many of the students who are following the NCRT books, which provided both the answers. Therefore, both the answers given by the students are based on the NCRT books, which is the basis for the basic examination for the NEET test. Therefore, they may not be, that question may not be deleted, and therefore the students who gave the correct answer may be given the marks that are due to them. That's all my submission.
Lordship, I am
Lordship,
appearing
in
for successful petitioners in IA number 140031.
You don't want a re-examination.
I don't want, Lordships, my humble
How many
submission.
people have argued that now?
One-
How many
Lordships.
people will just because you're for an intervener?
I understand, Lordships. One specific point, my lords. In Tanvi Salwal case, the Lordships interfered and cancelled the examination within 45 days. Whereas when it comes to we people, after the result was declared, there was a Rawlsian ignorance, wheel of ignorance, my lords, when it came to the candidates who were involved in Tanvi Salwar case. Whereas in our case, my lords, after we being declared successful, on the basis of a conclusive police report, Lordships interfered in Tanvi Salwar case. Whereas in this case, my lords, police report, CBI report is not as conclusive as what happened in that case, my lords. So we being successful, brought into the rigor of re-examination again, might be, my lords, it may be difficult for us. So on behalf of the successful candidates, I plead, Lordships.
Your Lordships, I am appearing in item 21.34. If your Lordships allow for re-NEET, we are covered. But if your Lordships do not allow for re-NEET, your Lordships, our relief is restricted to seeking parity with 1563 students. Your Lordships, we are the tribal students from Meghalaya who appeared from 2 centers, Reboi and Jowai. So, your Lordships, admittedly, there has been loss of time as apparent from the representations made by the center coordinators and also admitted by the NTA.
person is getting it.
Your Lordships, that has been also admitted by NTA in their response dated 17th of July.
Extra time for that. That's your individual grievance in regard to the Meghalaya student.
Please, Your Lordships, and
See what to do on that.
please, Your Lordship.
Your Lordship, in case there is no re-NEET, I would pray that if the answer, option number 4 is considered to be only correct answer, I would expect only if the,
My lord, I'm in item number 24. It is on a completely different tangent. Since 2020, before the Delhi High Court, we have been agitating that the NTA officials are involved in the swapping of my OMR sheets. My lord, in the digital.
We'll deal with your case.
My lords, I am also here with the same grievance. When the NTA answer sheet was released, I scored almost 509 marks. I had attempted 131 questions. And when the final result came out, I scored -6, which was very shocking for me.
Interestingly, the Delhi High Court had confiscated the OMR.
All good things.
Also, my lord,
At the blood, since this is the end of the hearing.
Mr. Solicitor, now, have you constituted a committee or something like that?
We have.
Now, what?
Yes.
Give us some idea about that.
We have. I'm sorry, my lord. I should have pointed that out, my lord. There is a 7-member committee, my lord. It's subject to your lordship's approval. it is. Yeah, yes. But it is R21 of the counter affidavit, page number.
R21 of the counter.
Yes, sir. It is headed by Dr. K. Radhakrishnan, former chairman ISRO and chairman Board of Governance, IIT Kanpur. And Dr. Randeep Guleria, former director AIMS Delhi. Professor B.J. Rao, Vice Chancellor, Central University of Hyderabad. Professor Ramamurthy K., Professor Emeritus, Department of Civil Engineering, IIT Madras. Shri Pankaj Bansal, co-founder, People Strong and board member of Karma Yogi Bharat. Professor Aditya Mittal, Dean, Student Affairs, IIT Delhi. Shri Govind Jaiswal, Joint Secretary, Ministry of Education, as a member secretary. Lord, it is placed at R21 with my counter, my lord, counter dated.
July.
4th July.
Return after 5 minutes.
Please. Lord, on the, since at the end of the day, on a lighter note, sometimes your lordships must be missing the virtual hearings where there is a facility of muting us.
We'll be back in 5 minutes. Dr. CJI has something, Mr. Paul? So after we come back after 5 minutes, all right. Then just come back after 5 minutes. Just take a comfort break.
Background of all those candidates,
That's all right.
10th, 12th and everything, because they
You're
are
not saying.
consistent.
Fair enough.
It's not only NEET.
You can't go into individual backgrounds because you know
Minutes. What I'm trying to say is that not only NEET they have performed well, but there is an exam of good set. Even in those exams, they have topped.
Fair enough. Yes, Mr.
My-
Wait, please, Lordship.
My lords, if I may.
Yes,
Lord,
ma'am.
on a,
Yes. Sir, I have a very limited purpose, sir. I seek to represent students belonging to tribal, rural, and basically remote areas and EWS categories from Madhya Pradesh. They are being represented by a socially minded teacher. She's a medical professor, sir. Sir, the issue here is that we face is that these students, some of them come from very remote areas, some are even Naxal regions. For them to access an exam center or even sit for a test once is a very expensive exercise, leave alone doing it again. Some of them have even qualified and they have been seeking assistance from professors and guidance during the ongoing litigation. All we request is that if a retest is ordered, these students may kindly be either exempted or some sort of exception may be made for the process to be eased for them, sir, where their prior scores may stand in case.
Ma'am, if we order a retest, we can't create an exception. Then logically we will be incorrect.
My lords,
Either we do it, we have to use the same yardstick for everybody. The fact that there may be students like your candidates coming from tribal areas, poor students will have to go through the entire process, may be a ground not to order a retest. But if you order a retest, then we can't start creating exceptions. Then there'll be our judgment will be very vulnerable. We then have to apply one cut across them.
my lords, in that case, I seek my lord's permission to assist
So
my lords
you
with
may,
the
therefore,
judgment.
your first point that we take it as a point that, ordering a retest
Sir,
will substantially prejudice students, especially students coming from the poorer backgrounds, marginalized backgrounds,
Sir.
like your class. That point we took.
sir, with your permission, if I may put forth my lord's observation in Sachin Kumar versus DSSB, which learned solicitor sir presented. So basically, by your lordship's principle, these students are obviously not beneficiaries of any paper leaks. And if they are put on the same yardstick as the wrongdoers, then it will be a violation of Article 14. That is my lordship's observation in the matter.
Point the learned solicitors also.
And such an exception has been made by the Judicature of Patna in Bihar STET leak few
Create
years
an exception only because, because then you belong to, say, tribal students. There may be Dalit students. There may be OBC students who also come from a very underprivileged background. Then where do we draw the line? There may be disabled students. Drawing a line becomes very difficult for the court, becomes a little arbitrary. So
I would seek your
but
consideration.
We've seen your first point. We'll
My lords.
take it.
Obliged.
Thank you. What's your name, ma'am?
Tanushri Bhalla. Obliged.
With Your Honor's permission, may I just make a submission? Your Honor, I will take less than 10 seconds. I'm appearing in IA number 140274 of 2024 in the lead matter. My Lord, I adopt the submissions which have been made by other contestants. I am also appearing for an applicant who has secured 658 and he is opposing the conduct of Re NEET. He opposes scrapping of the exam. The important thing why I'm addressing the Honorable Court is, my Lord, that there have been instances where unsuccessful candidates have approached high courts, sought orders against the NT, and the high courts have judicially determined that such prayers are being made on the basis of forged and fabricated documents. And in my IA, my Lord, I have appended the order passed by the Honorable Allahabad High Court on 18th of June. When a petitioner approached the High Court, he sought scrapping and all those reliefs, stay of counseling. The NTA appeared, produced original documents of the candidate. And it was eventually then the petitioner's counsel sought to withdraw the petition. And the High Court was kind enough not to penalize the student for filing fabricated documents. So, my Lord, the only submission is that this entire exercise, bona fide students are suffering. And some...
Your point.
Thank you.
Lord,
Yes, Mr.
basic principle which has been laid down by this honorable court is, if there is a leak, Lord, in this case, Lord, after the leak has happened, and the leak was done by the gang head, Lord, who has not been arrested, Sanjeev Mukhia. What is there in public domain, the CBI has not brought it on record. This Sanjeev Mukhia, who is yet to be arrested, is involved at least in 5 major paper leak cases in UP, Haryana, Rajasthan. These are the news items. It is to be verified by them. He's not been arrested. The moment, Lord, it is established that leak has happened, dissemination is through WhatsApp mode. The handiwork of a gang operating in different states. Now, Government of India taking a firm stand that the leak is now, the beneficiaries of the leak are confined only in Hazaribagh and Patna. And this confidence emanates from only and only one fact, that the accused in custody so far have said that the leak is confined to Patna and Hazaribagh. Patna police, when records 161 statement of the accused, they talk of leak prior to the date of examination. This is also 161. Subsequent 161 statement recorded by CBI probably indicates that the leak is on that date of the examination. Now, my Lord, when the CBI officer was talking to this honorable court, his expression, as I could gather, was that so far we have not been able to recover the mobile phones through which this dissemination happened. So we cannot say with confidence that this dissemination happened only in Patna and Hazaribagh and not beyond that. So unless, my lord, because after the leak has happened, the question paper is sold and there is sufficient time, even if the leak has happened on 5th, then, my lord, this honorable court ultimately, if sustains this examination, will have to record, in my view, a satisfaction on the basis of the material before this honorable court that we are able to segregate tainted from the untainted, and this satisfaction Lord, this Admittedly planning 2-3 months before by a gang. CBI officer specifically used very cautiously the word that so far we have not gone beyond Patna and Hazaribagh. CBI is not so novice that they will accept the statement of the accused arrested so far and close the investigation from the angle that whether it has gone beyond Patna and Hazaribagh. It is an evolving situation. The day we came first time before this honorable court for the writ petition, because mine was the first writ petition, we didn't know anything. Besides the fact that there were news items that there is a leak in Patna. Now, the main accused has not been arrested. Now, I would say the confidence with the learned Solicitor General to say that it is confined only and only to Hazaribagh and Patna is completely baseless. Investigation is going on. Can they file an affidavit that henceforth there would be no investigation to see whether it has gone beyond? If today the judgment come tomorrow, this Sanjeev Mukhia is arrested along with the mobile, which would show that he had sent it for 200 people in Sikar or different stations. I got to know that from Patna people have gone to Muxar, Punjab to give a paper. And if here they say 4 locations they have been able to find. Suppose there are 100 more locations involving only, say, 1,000 people involved into 20 centers. How many people would those figures, if all of them have got, all of them will not be topping, all of them will not get 720.
So would I just assist us on one aspect? If the court cancel the examination today, on the hypothesis that investigation is not complete, the main conspirator is yet to be arrested.
That's right.
And there may be a possibility, we can't say likelihood,
Correct.
but a possibility that in some future point of time, maybe even a foreseeable future, the leak may not be only confined to these 2
Correct.
cases.
That's right.
But should the court, in a situation like this where 23 lakh students have appeared, and we are dealing with the welfare of students across the country, and that's the worrisome part. We look at it this way, both ways. Let's put it 1 second. Let's put it both ways. We can't today. You are right, absolutely, that we can't say that the leak. We can't enter a judicial finding that the leak is confined only to Hazaribagh and Patna.
Correct.
For the reason that the investigation is ongoing.
That's right.
Even CBI can't tell us that. Today, as of now, it is confined to Hazaribagh and Patna. CBI's investigation in the next 15 days or 10 days might reveal a different, an evolving picture.
10 more locations.
So, we also, on the one hand, can't say that the leak is confined only to Hazaribagh and Patna. Equally, we can't today say with any degree of even prima facie authenticity or substance that the leak has gone beyond Hazaribagh and Patna in such a widespread or a systemic manner as to completely affect the sanctity of the entirety of the exam. That also we cannot say. Therefore, I asked that's why we want your assistance. Can the court, or would the court be justified in a situation like the one present to say that not on the basis of material which we have today, but on the hypothesis that some material in the future may show that the leak had gone beyond Hazaribagh and Patna. Therefore, today we cancel the exam on the basis of a hypothesis.
May I answer, my lord?
May not happen in future.
May I answer?
No.
When I speak,
Matthew,
when I wanted to speak, your lordship prevents
hear you.
me.
You please sit down.
No, I'm the among the lawyers here, I am the senior most.
Sorry, you're not an amicus. I have not appointed.
No, I am appearing for 16 students.
Right.
When I wanted to speak, the Honorable Chief Justice prevent me from speaking.
Mr. Matthew,
And I have an answer.
He is arguing. You will not interrupt him when he's
I am not interrupting, but I have an answer to say. I have an answer to give.
You don't answer my question. He is answering the question.
Okay, then, but another question. It's a
We're
general
not
question.
telling you he's on his
No,
leg.
I'm not interested in the
He is on his
engagement with
leg.
the Honorable Chief Justice, but I wanted to say,
You please sit down. I'll have to have you removed from the court. You please sit down. I'm warning you. I'll have to have you removed from
no,
the
your
court.
lordship doesn't
Mr. Udo,
respect me.
one second.
My own will leave.
Mr. Matthews, I'm telling you one very simple thing. Mr. Huda is engaged in a.
Your lordships have tried every best not to allow me to speak and put
right,
forward my
you have no
conventions.
right to intervene.
I'm not intervening, I'm leaving.
Yes.
But one thing is said, I wanted to say, I wasn't allowed to speak.
Yes, Mr.
When I was speaking, your lordship was showing the other side.
Yes,
And I have only one word to say, only
Yes,
one word
Mr.
leaving,
Mr.
one word to
Matthews,
say.
please call the security people, have him removed from the court, please.
I have only one to say.
You will not say anything. You will not speak to the gallery. You will listen to me. I'm in charge of my courtroom.
Listening.
You just keep quiet now. Yes, Mr. Huda. Yes, Mr. Huda. Yes, Mr. Huda.
I'm leaving.
Yes, Mr. Huda.
Unfair.
Yes, Mr. Huda.
Please.
This is not a judicial.
Mr. Matthews, I will now be constrained to issue something which is very unpleasant. Please keep quiet. Sit down here. You want to leave? It's your choice.
I'm leaving. I'm leaving.
You don't have to. You do not have to intervene. You don't have to tell me that you are leaving. Yes.
No, because I sought permission. I
See,
sought permission to speak.
Matthews, you will not interrupt Mr. Huda. I will hear you, but I'll hear you after Mr. Huda is done. I am in charge of procedure in this court, and I've seen this court. I've seen the judiciary for the last 24 years. I will not allow any lawyer to dictate the procedure of the court.
I've seen the.
I will give you a full hearing, but after Mr.
All right, all right,
done.
all right.
Yes.
I have
Now,
been,
please
I have,
keep quiet. Yes,
I have been
Mr. Huda.
seeing judiciary since 1979.
Yes,
Since 79.
may I, my lord,
This is contemptuous.
On 5 May 2024, and results were declared on 4 June 2024. So, in this batch of cases, the central issue which has been urged before the court on behalf of the petitioners is that a direction for that a direction should be issued for convening of a retest on the ground that bracket 1, there was a leakage of the question paper, semicolon, and bracket 2. There are systemic deficiencies in the modalities envisaged for the conduct of the examination. Full stop. The NEET UG examination was conducted at 4750 centers comprised within 571 cities, besides 14 cities overseas. Full stop. 23 lakh 33,000. Was it 162 or 297?
297. 297.
Total number of, no, you said now 162 in your note today.
297.
297 candidates appeared for the examination. Full stop. They are competing for 1.08 lakh medical admission at the undergraduate level, of which approximately 56,000 seats are in government hospitals, semicolon, 52,000, the balance 52,000 being in private institutions, privately managed institutions. Full stop. During the course of the hearing, the court has been apprised of the fact The 50th percentile represents the cutoff for qualification. Can I have a sheet? Can I have a sheet? That the 50th percentile represents the cutoff for qualification. To stop. The examination consists of 180 questions, each carrying 4 marks, thus making for a total of 720 marks overall. So 1 negative mark is assigned for an incorrect answer. Full stop. During the course of the NEET UG, based on the result of the NEET UG 2024, the 50th percentile has worked out to 164 marks out of 720. Full stop. All candidates who have attained at least the threshold of 164 marks is thus qualified, are thus qualified for being considered for admission. Full stop. The seats are allocated both among the general category of students and the reserved category, consisting of the scheduled castes, consisting of candidates belonging to the scheduled castes, scheduled tribes, other backward classes, and economically weaker sections. Full stop. In view of the full stop, the submission which has been urged on behalf of the petitioners is that the leak which took place in the course of the NEET UG examination is systemic in nature and coupled with the structural deficiencies in the modalities for the examination, the only course of action which would be permissible in view of the previous decisions of this court, including in, what is that citation? The first one? Tanvi's case? 2015, including in Tanvi Sarwal versus Central Board of Secondary Education, 2015, 6 SEC 573, and so, 2021, 4 SEC 631, is to direct a retest. Full stop. By an interim order dated 8 July 2024, while flagging the principal issues in contention, this court had called for a disclosure on affidavit by the National Testing Agency, the Union of India, and by the Central Bureau of Investigation. Full stop. The role of the CBI has been implicated because the FIRs which were registered in Delhi, Gujarat, Rajasthan, Jharkhand, Maharashtra, and Bihar have been transferred to the central agency for investigation. Full stop. Essentially, in the earlier order, this court noted that it would have to scrutinize the following aspects on the basis of the data which would emerge on the record, namely, 1, whether the alleged breach took place at a systemic level, semicolon. 2, whether the breach is of a nature which affects the integrity of the entire examination process, semicolon, and bracket 3, whether it is possible to segregate the beneficiaries of the fraud from the untainted students. Full stop. Direct consequently issued to the above agencies of the Union to make specific disclosures on the issues which have been highlighted in the previous order. Full stop. Arguments have been heard over 4 days, and we have had the benefit of considering submission urged on behalf of the petitioners, the Union of India, and the National Testing Agency. Full stop. Our CBI officer is Mr.
Mr. Krishna is additional director.
Mr. Krishna.
Yes. Additional director CBI.
Additional Director CBI has appeared in the course of the proceedings to apprise the court on the status of the investigation. Next. You can say the 100. Arguments have been concluded and judgment has been reserved. Full stop. In a matter like the present, it is imperative that the final conclusions of the court be disclosed at the present stage, should be recorded at the present stage, since there is an urgent need to bring about the urgent need to provide certainty and finality to a dispute which has affected, to a dispute which affects the careers of over 2 million students. Full stop. The reasons for the ultimate conclusions will follow later, but we proceed to record the essential conclusions in the following terms. Colon. Bracket 1. The fact that a leak of the NEET UG 2024 paper took place at Hazaribagh, the state of Jharkhand, and at Patna is not in dispute. Semicolon. Bracket 3, bracket 2. Following the transfer of the investigation to it, CBI has filed its status reports dated 10 July 2024, 17 July 2024, and 21 July 2024. Stop. The disclosures by the CBI indicate that the investigation is continuing. However, CBI has indicated that at the present stage, the material which has emerged during the course of the investigation would indicate that about 155 students drawn from the examination centers at Hazaribagh and Patna appear to be the beneficiaries of the fraud. since the investigation by the CBI has not attained finality as at the present point of time, this court had, in its previous order, required the union government to indicate whether certain trends in regard to the existence of normalities or otherwise would be drawn on the basis of the results emanating from the 4,750 centers situated with 571 cities. Full stop. Pursuant to the directions of the court, union government has produced a report of IIT Madras indicating the position on the basis of data analytics. Full stop. Full stop. The objection of the petitioners to the report of IIT Madras to be considered in the course of the judgment, in the course of the recent judgment, which will follow. Full stop. At this stage, in order to obviate any controversy, the court has independently scrutinized the data which has been submitted on the record by the NTA. Semicolon. Bracket 4. At the present stage, on the basis of the material on the record, it is not possible for the court to come to the conclusion that at the present stage, on the basis of the material on the record, at the present stage, there is an absence of material on the record sufficient to lead to the conclusion result of the examination stands vitiated, or that there was a systemic breach in the sanctity of the examination. Semicolon. 5. Added to the absence of conclusive material on the record at the present stage, the data which has been produced on the record, city-wise, center-wise, and the comparison for the years 2022, 2023, and 2024 is not indicative of a systemic leak of the question paper, which would indicate a destruction of the sanctity of the examination. 5. In arriving at the ultimate conclusion, the court is guided by the well-settled test on whether it is possible to segregate tainted students from those whose candidature does not suffer from any taint. Moreover, it would need to be clarified that if the investigation reveals the involvement of an increased number of beneficiaries than those who are suspects at the present stage, action shall be pursued against any student found to be involved in wrongdoing at any stage, notwithstanding the completion of the counseling process. We'll stop. In other words, no student who is revealed to have engaged in acts of fraud or to have been the beneficiary of malpractices would be entitled to claim the vested right or interest in the continuation of the admission in the future. Semicolon 6. The court has also been mindful of the fact that directing a fresh NEET UG test to be conducted for the present year would be replete with serious consequences, some of which serious consequences for over 2 million students who have appeared at the examination, including in particular, bracket 1, disruption of the admission schedule for the commencement of medical courses. 2, cascading effects on the course of medical education, semicolon, bracket 3, a prejudicial impact on the availability of qualified medical professionals in the future. And 4, a serious element of disadvantage to the marginalized groups of students for whom reservation has been made in the allocation of seats. Seven, for the above reasons, we are of the considered view that ordering a retest of ordering the cancellation of the entire NEET UG 2024 examination is neither justified on the application of the settled tests which have been propounded in the decisions of this court on the basis of the material on the record. One of the questions in the course of the NEET UG 2024 was in the following terms. Colon, वो IIT के रिपोर्ट में हम आप लीजिए given below आया था.
Yesterday's order.
कल के ऑर्डर में है. Initially, the answer key which was prepared by the NTA indicated that the fourth of the above options was the only correct. That the fourth of the options extracted above was the correct answer. Subsequently, on a large number of representations submitted to NTA, a decision was taken to the effect that both the second of the above option as well as the fourth option would be treated to be the correct option. Would be treated to be correct answers. Full stop. By an order of this court dated 22 July 2024, the director of the Indian Institute of Technology, Delhi, was requested to constitute a 3-member committee to submit its opinion on which of the options noted above would be the correct option, would be the correct answer to the above question. Full stop. The Professor Rangan, the director and professor of the Department of Energy Science and Engineering at IIT Delhi, has in his report dated 23 July 2024 indicated that a three-member committee from the Department of Physics comprising of colon 1, Professor Pradipta Ghosh, 2, Professor Aditya Narayan Agnihotri, and 3, Professor Sankalpa Ghosh, was constituted for that purpose. Stop. The expert team constituted by the director IIT has opined that option 4, as extracted above, is the correct answer. Stop. In order to obviate any ambiguity, option 4, which is to be treated as the correct answer, is set out below into invert commas. Statement 1 is correct, but statement 2 is incorrect. Stop. In view of the expert determination by the team constituted by IIT Delhi leaves no manner of ambiguity in regard to the correct option, which was in fact initially the only option which was treated as the correct answer by NTA. Full stop. Options 2 and 4 are mutually exclusive and both cannot stand together. Full stop. We accept the report of IIT Delhi. Full stop. Accordingly, NTA shall revise. This is the result of the NEET UG 2024 on the basis that the correct answer, that option 4, as set out, as extracted above, represents the only correct answer to the question. Full stop. We have not indicated the number of the question since the number of the question, since the actual number on different answer booklets, on different OMR sheets, or since the number of the question is likely to vary in view of the procedure which is followed.
Yes.
The number of the question as well as the option is likely to vary in view of the procedure which is followed in the examination to preserve the integrity of the process. The next, during the pendency of the proceedings.
Negative marking, your lordships were considered.
No, we'll just leave it at that. I think we'll not. During the course of the hearing, the court had been apprised of the fact that NTA would be conducting a special test for 1563 students in supersession of the compensatory marks which were awarded. The students were given an option of either appearing for the special test. The 1563 students were given the option of either appearing for the special test or, in the alternative, opting for their original marks without the addition of compensatory marks. Full stop. NTA is permitted to act accordingly following the test which was held. Next. Since the only question which has been, apart from the question which has been, the principal issue which has been urged before the court relates to the sanctity of the NEET UG 2024 examination, whether the process was required to be scrapped and a fresh test was to be reconvened. Full stop. Having answered the question in the above terms, it needs to be clarified that if any student, including in the present batch, has an individual grievance not bearing on the issues which have been resolved by this judgment, it will be open to them to pursue their rights and remedies in accordance with law. The competent high courts, the jurisdictional high courts under Article 226 of the Constitution. Full stop. If any, however, before moving the High Court for the grant of relief, the petitioners would have to seek the withdrawal of their petitions before this court, if they have been filed. Full stop. Then we'll finally say, during the course of the hearing, the court has been apprised of the fact that the union government has constituted a 7-member expert committee chaired by Dr. K. Radhakrishnan. Radhakrishnan is a former director of ISRO, former director of former chairman of ISRO. Full stop. The committee will abide by the committee and consisting of the following members will be Nam. Full stop. The committee will abide by such further directions as may be issued by this court in its final judgment and order in regard to the areas which should be divided into by it, so as to ensure that the process of conducting the NEET, UG and other examinations falling within the remit of the NTA is duly strengthened so that the instances which came to light during the course of the present year are not repeated in the future.
There were some transfer petitions filed by NTA on this issue itself. They stands disposed of.
The transfer petitions raising the issue as regards the validity of the NEET UG 2024 examination shall stand disposed of in terms of the above directions, subject to the clarification that individual grievances, if any that remain, may be addressed before the competent high court, before the jurisdictional high court.
Grateful for the patient hearing.
Thanks.
So grateful.
Sorry?
Said you have to withdraw the writ petition. In fact, I've only filed an IA. So I'll withdraw that IA before your lordship because tomorrow counselling will start.
The IAs raising individual grievances are similarly permitted to be withdrawn.
Yes, Lord.
Liberty reserved in the above term.
Yes.
My lord, a small mention, my lord. My lord, a small mention with great respect. My lord, this is regarding item 21.24. I may be allowed to withdraw my petition, my lord, because it has been tagged with Vanshika Yadav, in which the broad arguments have been addressed.
Anybody else who is present here and who wants to withdraw their petitions, just come and tell the courtmaster, apart from 21.24 who's online, he'll just record it and we'll make sure that that is withdrawn so that you don't have to move another court, another time. Yes. Do it right now so you can move
tomorrow counselling will start.
I'm so much grateful, my lord.
1.33, my lord. The report may remain for your lordship's perusal. Otherwise, we can apply for certified copies. Inspection of certified. Your lordships may need it, my lord, for judgment writing.
After the judgment is delivered, then we'll return it back to you.
Yes, yes. In the meanwhile, parties can apply for inspection or certified copy.
Of the CBI report. Yes, so the CBI report will be maintained with.
Yes, yes. That's all I'm requesting.
Because it's an investigation report. Otherwise, the whole investigation may be derailed if we disclose it at this stage.
Can I? Lordship says not right time to mention. Item 6 and 9 I'm mentioning.
Yes.
These are the two matters. 9 is Shiv Sena, 6 is NCP.
Yes.
The Lordship had intended to have it urgently heard, but NEET overtook us. The Lordship may give us the shortest possible time. I'm only at the moment asking, one second. Yes, I'm asking for the shortest possible time. That is 9th, because otherwise the thing is completely infructuous. One way or the other, elections are there.
differences from current account and savings account deposits, that is CASA deposits, has various implications which banks need to keep in mind.